Hi, this is Paul. Thanks for jumping on Wealth Protector TV. You might be listening on Wealth Protector Radio, and I'm here with my colleague Brent, one of our expert attorneys, asset protection, estate planning, business planning. This question came up recently, so I wanted to pose it to Brent, and it's dealing with dementia and estate planning, because what happened, Brent, you and I were talking offline recently, is an individual came to us and they are involved with their parents who have been officially diagnosed with dementia. Unfortunately, this is a big thing going on today for a lot of us, and they didn't have any estate planning. So my question to you was, what happens if that scenario occurs?
Yeah, so it's a great topic to get out there. This is one of these things, Paul, that comes up quite a bit. So what we see happening is, it's not just Alzheimer's and dementia. That seems to be exploding at this point.
Right.
The issue, though, is it can happen to anybody, and it usually presents itself with kids coming in. The kids coming in going, I'm concerned, I'm not sure what to do at this point. We need to do some planning because some things are moving really fast. And the first question that comes up is, for us as the lawyers, is what documents do they have now that can help, and do they have any? And then we find out the answer to that. And then the next question that comes up is going to be, do they have capacity? Do the parents know what's going on? Are they able to? Do they have the capacity to actually make some new documents if we needed to? And that's really going to drive the direction of where that's going to go, if it's going to be a good conversation or a bad conversation.
And so if they don't have any planning and the diagnosis comes, you mentioned sort of I think you called it the probate for the living, which would be conservatorship. So what's that worst case scenario?
So here's the problem. If we have a situation where the person doesn't have capacity at that point to create anything new, and they don't have documents, they don't have a power of attorney, they don't have a healthcare directive, these living documents that we all should have at this stage, it's a problem, and it means that we now need a court to jump in and direct things. So in our world, the worst thing we can think of as estate planning attorneys is we don't want anybody going to probate.
Right.
The next thing is conservatorship, because what that means is now we're going to a court-driven process where a judge is going to decide what to do, whether the kids are the right people to do this, maybe a spouse that's there
right.
can do this. Who has the ability to do it? And the issue is it's a weird process to go through, because the courts don't really want to get involved in any of this stuff. They don't know what the person wanted. They don't
right.
know, what their goals were here.
Sounds like a mess.
It's a total mess. It turns into a hairball mess, and then now what happens is that you got the family scrambling around paying a bunch of legal fees that they don't want to pay. They've got to check in with the court periodically to give them reports on how things are going.
Oh my Lord.
And have to do things like posting a bond on the house and all sorts of stuff that could have been prevented had they had the proper documents, a good power of attorney, healthcare directive in advance. And so it comes down to, I see this a lot. We have proactive families and we have reactive families. And the reactive that just react to these issues, the issue is, are we too late?
Right. And even you said, it was interesting, is if you have a power of attorney, I said, okay, what if you have a power of attorney, that's all you have? And you said, well, hopefully it's the right power of attorney. It has the right language in there to allow them to do A, B, and C.
Good point.
Is that right?
Yeah. So what often happens is, what people are concerned about is, so people have worked their whole life to accumulate whatever they have. It can be the family house, can be a family house and some money in the bank and a 401k and all these things. And the issue is they may need some really big care, and the care could be $10,000 a month plus care for somebody to get some good care.
Easy today.
Yeah, no problem. And so are we going to lose things like the family house? Are we going to lose all this money in the bank, everything, just so they can get proper care? And so with the correct documents in place that allow a power of attorney to come in, maybe it's their kids or the spouse that's doing better, to come in and actually do some good planning, maybe do some gifting, maybe do some trust planning where we're setting up Medi-Cal type of trust and things that can do some really some good. It can come down to, are we going to be able to keep some assets here, or do we have to literally watch everything go away to get some help from mom and dad?
So
it's a big deal.
Yeah. Well, my takeaway for all those listening, Brent, you probably agree, is if you're helping your elderly parents, or if you're involved with them at all, or anybody that you know, put a microscope on this and make sure the planning's done right, airtight, because it becomes a hornet's nest if you don't.
Yep. Have the conversation and get it started. Yep.
All right. Thanks so much for jumping on.
Thanks.